Georgetown decided to adopt the TED Talk approach, and so I did the first Ed Talk, which is not, thankfully, erectile dysfunction, as it is everywhere else, but it's electronic discovery. So I did the first TED Talk, and I was very fortunate to have also be joined by talks delivered by Erin Cruz and Jason Barron, who are both terrific and well known in this space. The Ed Talks, like TED Talks, are individual talks. In my case, I talked a little bit about my journey, having spent the last 30 years teaching lawyers about technology, and tried to lay out a sort of a challenge and a manifesto. I couched it as a concession speech because, of course, this is the week where the election came out and not everybody got the concession speech they were hoping for this week. And so my concession speech was essentially conceding that lawyers had outsmarted me these 30 years. I thought by now they'd be reasonably proficient and competent when it came to electronically stored information, but they have proven more ingenious than my best efforts, and they have continued to not be competent. So I laid down the gauntlet. And in my Ed Talk, I laid out a blueprint for how we must change the process of teaching electronic discovery moving into the next generation, how we must teach the teachers so that instead of simply teaching law students about the decided decisions of eDiscovery, which are largely unchallenging, and happily law students already have the gifts instilled in them of how to read the law, we need instead to have a group of well-informed eDiscovery teachers who can lay out the E in eDiscovery, the fundamental technologies, whether it be the means by which data is stored, the variety of data, the forms and encoding of data, the proper forms of production, how to analyze costs, how to properly preserve, identify, process, etc. And so I spoke about the various steps we need for a kind of Manhattan Project in order to, as I put it, can lawyers be saved? Can we salvage the skills of an experienced generation of lawyers who know how to try cases but know much about eDiscovery, and meld their experience with the necessary technologies to make them stay relevant, as well as make them appropriate teachers to bring in the next generation? With so few trials today, there's almost no way, unless you happen to be in the JAG or a prosecutor or a defense counsel in criminal cases, you just don't see the inside of a courtroom. So we have to find a way to pair the experience of the trial dogs of the last generation with enough knowledge of the electronic discovery that they can be viable teachers to the next generation. They can be the mentors that the apprenticeship approach to education has always required, so that experienced lawyers could hand down the actual pragmatic practice of law to the next generation of lawyers, something interrupted at this point. I'm excited about some new tools and new environments. I find the cloud to be the promise of a great many useful ways for us to solve problems. I'm pleased seeing what I'm seeing in, say, Office 365 and the growth of viable and practical eDiscovery features that are baked into the tools used by our clients. Because in order for eDiscovery to truly be what its promise has always been, the tools of identification and the tools of preservation need to be built in at the client. Preserving in place is the most economically viable, and I hope someday, I hope I live long enough that everyone will come around to see the wisdom and economy of producing in native and near native forms. Something which I know about which I will ultimately be vindicated, but now there are people with their heads in such dark places for that sort of thing. I think the Internet of Things is great, in part because people get so confused about Internet of Things. While it's a bunch of sensors out there, the data that comes from those sensors is being conglomerated in apps and databases, so it will actually be easier to avail yourself of that very useful information. It won't require computer forensics. It's going to actually be much easier to use in the context of practicing law. But the key there, Angela, is lawyers must stop thinking about documents and begin focusing on data. Evidence isn't documents for the most part anymore. Evidence is data. And when lawyers understand data, they'll understand electronic evidence.